P.O. Box 195 Charlestown in Davis, or give us a call. Our numbers are 1-869-469-1616 and or 1700. And by the way, those will be the numbers you'll use to be a part of this evening's discussion. Again, thank you all very much for joining us. This is your voice in the community, thought that get results. With regard to your participation in the show, we encourage you to call in on the numbers listed 1-869-469-1616 and or 1700. Here's a suggestion. You have a question or a comment, perhaps you can get a pencil, piece of paper, write it down so that you're well organized, and when you're getting on the show, you take as little time as possible so that we can accommodate as many of you as we can. We ask only, first of all, you respect yourselves and then respect others, because we will not accept anything we deem that's not within our broadcast standards, but we encourage you to always be forceful with your point. You can also follow us on our YouTube channel and also on our Facebook page at Vaughan Radio. Thank you all again for joining us tonight. The Integrity Commission of Nevis, discussing the integrity in public life ordinance. We thank them very much for taking our invitation to be on this show to have the discussion with you, the listeners, and the general public. The chairman of the commission is Mr. Ricardo Keynes. Good evening, Mr. Keynes.
Good evening, Mr. Herbert, and good night to the general public out there on Nevis, the Federation, and on the internet worldwide.
You are the chairman of this commission, Mr. Keynes, and why don't we do it this way? Allow you to introduce the other members of your commission.
Thank you, sir. My name is Mr. Ricardo Keynes. I'm an attorney at law, and I'm the chairman of the Integrity Commission on Nevis. We have two other commissioners with myself here tonight, Mr. Sidney Newton, an agriculturalist and banker, general manager of the Nevis Credit Union. He was appointed by the Deputy Governor General for the island of Nevis on the recommendation of the Honorable Premier, Mr. Mark Brantley. We also have with us tonight Mr. Alfred Tyrrell, former banker, retired banker of the Eastern Caribbean Central Bank. He was appointed by the Deputy Governor General for the island of Nevis on the recommendation of the then Leader of the Opposition, the Honorable Joseph Parry. The three of us make up the commission, the Integrity Commission for the island of Nevis.
And what we would want to do, first off, Mr. Keynes, is because we've heard of the Integrity in Public Life Ordinance, and I must admit, including myself, I don't know, and a lot of folks don't know exactly what that means, either in legal terms or even in layman language. So let's start with that. Tell us what the Integrity in Public Life Ordinance is all about, what it sets out to do, then we can get into the details thereafter.
Yes, sir. The Integrity in Public Life Ordinance 2013, it was passed in the Nevis Island Assembly on the 11th of September 2013. The commission was established in 2018 when the three of us were appointed sometime in June, and the office commenced operations on the 3rd of June 2019. The Integrity in Public Life Commission was established to ensure integrity in public life, to obtain declaration of the assets, liabilities, income, and interest in relation to property of persons in public life, to give effect to the provisions of the Inter-American Convention Against Corruption in the island of Nevis. The Commission, in its establishment, consists of 3 members who are the commissioners, with myself being the chair, and we have 2 employees who work with us at the commission, which is located upstairs the Rams building. The ordinance basically sets out in 3 parts the commission financial disclosure in part 2 as to the persons who have to disclose and the type of documents they have to disclose to us, and part 3 that deals with the regulations and the financial provisions. Now, what I will do in my presentation, I will basically just walk persons through the basics of the ordinance, and then the other two commissioners will deal with different aspects of it as we go through tonight.
Okay, very well.
The commission was established, as I stated earlier, in 2013. The ordinance was enacted, and it came into force by a date fixed by the minister that was published in the Gazette. The first part of the ordinance basically deals with what we call the interpretation section, and what that does, it basically tries to tell in the ordinance the persons who are then captured by the legislation. So, for example, one of the definitions of persons in public life means a person who holds an office. In the case of permanent secretaries and heads of departments, where such persons hold an active appointment for a period of not less than 12 months. Public body. This includes the Nevis Island Assembly, Cabinet and Cabinet committees, a ministry or department of government, a corporation established by an act of the Parliament of St. Kitts and Nevis, or by an ordinance of the Nevis Island Assembly for a public purpose, or as a subsidiary company of that corporation registered under the Companies Act or the Companies Ordinance, a bank or company owned by the state or the Nevis Island Administration, or in which the state or the Nevis Island Administration has a controlling interest, a commission, statutory board, public authority, or other body of any description, whether its members are paid or unpaid. Public function. The legislation defines public function as means any activity performed a single time or continually, whether or not payment is received for it, and which is carried out by a person for or on behalf of or under the direction of a ministry, department of government, a statutory body, local government authority, or a government company. B, a body, whether public or private, providing public utilities, including the provision of water, electricity, and communications. Or C, a member of the Nevis Island Assembly in that capacity. Public servant. The ordinance defines a public servant as any person A, employed 1, in the civil service of the Nevis Island Administration, 2, in the service of a statutory body or authority of a public body, B, who is an official of the Nevis Island Administration in any of its agencies, and C, approved, elected, selected, or otherwise engaged to perform a public function. The definition for property means money or any other movable, immovable, corporeal, or incorporeal thing, whether situated in the state, that is St. Kitts and Nevis, or elsewhere, and includes any rights, privileges, claims, securities, and any interest therein, and all proceeds thereof. Also, the legislation seeks to define a child means a child of a person who has not attained the age of 18 years and is not married, or having attained that age is under the age of 25 and not married and is pursuing a course of higher education, and includes a stepchild or an adopted child, and in respect of a man includes a child born out of wedlock, of whom the man had been adjudged the father by a court of competent jurisdiction, or whom the man had acknowledged to be his own child. So, who does the ordinance apply to? The ordinance applies to every person in public life. And for the purposes of the ordinance, that means A, the income of a person in public life is that income which he acquires in or out of the state of St. Kitts and Nevis, and includes all prerequisites or benefits, direct or indirect. B. The assets of a person in public life are all the property beneficially held in the state or elsewhere by him or her, and all rights and benefits to which he or she is entitled. C. The liabilities of a person in public life are all the obligations of such a person to pay money or to transfer money to others, whether in the state or elsewhere. The composition and the appointment of the Integrity Commission under the ordinance is as follows. The Commission is a state functionary established under the ordinance. The Commission comprises a chairperson and 2 other members. All appointments are for a period of 5 years. All members are appointed by the Deputy Governor General, acting after consultation with the Premier and the Leader of the Opposition. Membership must include either a retired judge or an attorney at law for at least 15 years standing to be the person as the chair. In making these appointments, the Deputy Governor General must be satisfied that the person is a person of high integrity, capable of exercising competence, diligence, sound judgment, and impartiality in fulfilling his or her duties. Functions of the Commission. The function of the Commission is to receive, examine, and retain all declarations filed pursuant to the provision of the ordinance, to make such inquiries as it considers necessary in order to verify or determine the accuracy of any declaration filed pursuant to the ordinance by a person in public life, without prejudice to the provisions of any other law, in St. Kitts and Nevis, conduct an investigation into any allegation of bribery or act of corruption under this ordinance, and D. To perform such other functions as may be required pursuant to the provisions of this ordinance. The powers of the Commission. The Commission shall have the powers, rights, and privileges of the High Court at a trial in respect of enforcing the attendance of witnesses and examining them on oath, affirmation, or otherwise, compelling the production of documents, and C. The issue of a commission or request to a witness abroad. The forms for the summons of the attendance of a witness or any person is basically contained in what we call the schedule to the ordinance. The independence of the Commission. The Commission shall, in the exercise of its function under the ordinance, not be subject to the control or direction of any person or authority. So we are now moving into the financial disclosure, which we consider part 3 of the ordinance, and I will hand that section over to Commissioner Sidney Newton.
Good evening, Webbo, and the listening public. I'll continue with financial disclosures, part 3 of the ordinance, sections 15, which speaks to the duty of the declarants to furnish declarations. Persons in public life shall file a declaration of income, assets, and liabilities for him or herself, the declarant, for the spouse and children of the declarants. Declarations must be submitted on Form 1 of Schedule 3 and Form 2 of Schedule 3, and that I will look at a little later. A person becomes a person in public life after the commencement of this ordinance. He or she shall not later than 3 months of becoming a person in public life file with the Commission a declaration in Form 2 of Schedule 3 as referred to earlier. The declaration shall be filed irrespective of the fact that during the income year in respect of which the declaration is required, or in the following 2 income years, the declarant ceased to be a public official or a person in public life, otherwise than by reason of death, So a person leaving the public service is required to file declarations up to 2 years after leaving that office. Where a person is or who is required to do so fails to file a declaration in accordance with this section or without reasonable cause, fails to furnish further particulars in accordance with section 20, the Commission shall publish such fact in the Gazette and at least one newspaper in general circulation on the island of Nevis. And sadly, that had to be done sometime last year. The Commission may at any time, after the publication referred to in subsection 6, make an ex parte application to the High Court for an order directing such persons to comply with the ordinance, and the Court may, in addition to making such an order, impose such conditions as it may think fit, including costs. A person who fails to comply with the directions of the Court commits an offense and is liable on conviction to a fine of $50,000. The ordinance speaks to trust property in section 16 and 17. It says that a person in public life who holds money or other property in trust for another person, he or she shall so state this in his or her declaration. In other words, wherever a person's name appears on any particular assets, be it cash, liquid assets, investments, property or otherwise, must declare it in their declaration. In relation to income, assets, liabilities of agents, the ordinance says for the purpose of a declaration, the income, assets, and liabilities of a person in public life include the income, assets, and liabilities acquired, held, or incurred by another person as his agent or on his behalf. So one cannot just callously hold money for other people and not expect to declare it, because if it is disclosed in by some other means, that is construed as a violation of the ordinance. What happens when someone files? The Commission examines every declaration received. And as Mr. Keynes, the chairman, said earlier, there are members of staff who are employed to do particular tasks in relation to receiving declarations and examining them to ensure that they meet the required standard. The Commission may at any time thereafter request of persons in public life any information or any explanation relevant to a declaration made. In other words, one just don't declare without explanation, because there must be sufficient supporting documents to confirm what is being declared. And if there isn't sufficient, then they are required to give authority to the Commission to seek that information or clarification from the sources. The Commission may require a person in public life to file such particulars relating to his or her financial affairs at the Commission considers necessary for the purpose of above section 19(1) within 1 month or any longer period as specified. And the Commission may, upon examination of a declaration filed pursuant to section 15, require a person in public life to appear before the Commission at a specified time to be heard on any matter relating to the declarations. And it is interesting to note that when a persons are required to appear before the Commission, they could attend accompanied by or represented by an attorney at law, a certified accountant, or both. And they will require the Commission. The Commission could also summon witnesses. So it's a very elaborate process when one gets into the details and operations of the Commission. The simplest form is to file the declarations and have them examined with all the supporting documents. And if the commissioners are satisfied that, based on what they see, that there is nothing untoward, then a certificate of compliance is issued. Until such a time, there are procedures to follow to give comfort that the information is reasonable and reliable. The Commission shall not make any adverse decision without giving the person in public life an opportunity to be heard. Where upon examination of the relevant documents, the Commission is satisfied that a declaration has been fully made and all questions satisfactorily answered, the Commission shall, pursuant to Section 19(2), publish the Certificate of Compliance in the Gazette, so that because it is a public duty, we let the public know who has complied, and likewise in the Gazette we let the public know who have not complied. Earlier I spoke to the Form 2, and the form in which declarations are made basically requires persons to provide information on their bank accounts, cash which they hold in excess of $10,000 in institutions other than banks, and not only for themselves but also for their spouses and children. It also speaks to bonds, stocks, shares, and other similar investments which the declarants may hold, not only for themselves but also for spouse and children over which they have a right of disposition. So they have some control over those funds. They are also required to report on or declare matters related to immovable property, such as house, land, farm buildings, and things like those, for themselves, their spouses, and children under the age Mr. Keynes referred to earlier on. And money is invested in mortgages or business ventures, whether it be crops, livestock, or any factory or such the like. The declarant is expected to make declarations in these matters. Motor vehicles owned by or on hire for a period of time or loaned for a period in excess of 2 months, the declarant is expected to declare these for themselves, their spouses, and their children. Valuables held in safety deposit boxes, insurance policies, whether they be life, vehicle health, or otherwise, are all required to be disclosed. And of course, any other property owned by the declarant, not mentioned earlier, or by his or her spouse, or their children over whom they have jurisdiction. So, and all of these documents are required to have supporting documents as well, to give comfort and to provide the evidence that indeed they are factual. And note that they are not only for the declarant, but also for spouse and children under the specified age. It's not a very complicated process. It involves some getting done, yes. We are still working through the process that some documents which do not change over time could be submitted once, but there are things that require change every year, such as bank statements with balances which change from year to year and such alike. And so that concludes basically the financial disclosure requirement. And so I pass over to Mr. Commissioner Tyrrell for the latter part of the presentation.
Thank you, Commissioner, and good evening to all our listeners. I will wrap up the discussion on the ordinance, and I will speak to secrecy and confidentiality as they apply to the functions at the Commission, offences and penalties that are applicable to these offences. A declaration filed with the Commission is secret and confidential and shall not be made public. Let me say that again, that a declaration filed by the Commission is secret and confidential and shall not be made public. Let me just quickly go back and refer to the introduction made by Chairman Keynes, that my fellow Commissioner Newton is a General Manager at the Credit Union. Mr. Keynes, the Chairman, is a lawyer of many years, and he introduced me as a retired central banker. I said that to say that these three commissioners understand what confidentiality is. And I say that to allay the fears of people on the, who are declarants, to let them understand that when they submit their documents, that they are kept secret. Exceptions to the confidentiality rules in cases where a particular declaration or record is required to be produced for the purpose of or in connection with any court proceedings against or inquiry in respect of a declarant under this ordinance, the Commissions of Inquiry Act or Perjury Act. We speak of the secrecy and confidentiality, that a commissioner or an employee of the Commission who performs any function in the service of the Commission shall treat all declarations or information relating to such declarations as secret and confidential, and shall not disclose or communicate to any unauthorized person or allow any such person to have access to any such declarations or information. And the writers of the ordinance took this to be so serious that the penalties are almost biblical. And the penalties for disclosing information to an unauthorized person is anyone who contravenes, commits an offense, and is liable on summary conviction to a fine of $50,000. Let me repeat that, $50,000, or a term of imprisonment of 5 years. And if the judge feels like it, he would impose both. And so this is a very serious thing, and we take our duties serious, and so we are imploring on people to take us serious. Any authorized person who publishes information which comes to his or her knowledge pursuant to Section 1 in the ordinance to an unauthorized person commits an offense and is liable on summary conviction to a fine of $50,000 and the 5 years. For the purposes of this section in the ordinance, let me just explain what an unauthorized person is. It's a person other than a person authorized to receive information. Under this ordinance, in relation to the financial affairs of a person in public life, or by reason of an order of a judge or the High Court, other than that, information filed at the Commission cannot and will not be divulged. A person who fails without reasonable cause to furnish to the Commission a declaration or further particulars thereof, which he is required to furnish in Section 19 of the ordinance, makes a declaration which is knowingly false in some material particular, fails without reasonable cause to give such information as an investigatory tribunal may require under section in the ordinance, fails without reasonable cause to attend an inquiry being conducted under Section 23 of said ordinance, or gives any false information in an inquiry, commits an offense, and is liable on summary conviction to a fine of $50,000 or to imprisonment of a term of 5 years or both. Such fine and imprisonment a person who aids, abets, or facilitates another person in the commission of an offense under subsection 1 commits an offense, and the first mentioned person is liable on summary conviction to a fine of $20,000 or to imprisonment for a term of 2 years, or to both such fine and imprisonment. With the offense under subsection 1, the ordinance, this section, involves the non-disclosure of property acquired while in public life. The court may, if satisfied that such property was acquired but not declared as required under this ordinance, in addition to the penalty specified under subsection 1, A, where the property involved is situated here in this St. Kitts and Nevis, declare that it be forfeited to the Crown. Let me read that again. That if a declarant fails to disclose during the time that they are in public life, and they fail to disclose any property situated in St. Kitts and Nevis, their property involved is declared that it be forfeited to the Crown. If that property is outside of St. Kitts and Nevis and not reported, that amount equivalent to the value of the property be paid by the person in public life to the Crown. So if a declarant has a piece of property outside of St. Kitts and Nevis undeclared, that value of the property, the declarant will be asked to pay the value of that to the Crown. Any property acquired from a person, let me say this again, that any property acquired from a person referred to in the previous subsection by a bona fide purchaser for value without notice of any offense by that person is not liable to forfeiture, but an amount equivalent to the value of the property or the price paid by the purchaser, whichever is the greater, shall be paid by the person in public life to the Crown. the payment of all sums due to the Crown also may be enforced as a debt due and owing to the Crown, and any proceedings thereon on behalf of the Crown may be taken and maintained by the Nevis Island administration. Repeat that again, that any payment that is of the payment of all sums due to the Crown as a result of forfeiting property or declarants having to pay for value of property that they didn't declare, those sums are collected on behalf of the Crown and may be taken and maintained by the NIA, the Nevis Island Administration. Code of conduct, that the ordinance speaks to a number of behavioral matters that are expected of persons in public life. It's quite a list, so I'll just mention more 1, 2, 3 of them. That the code of conduct, that every person in public life shall observe the body of rules known as the code of conduct. A person in public life who is in breach of the conduct shall be subject to disciplinary proceedings by the Public Service Commission, or the Commission may report the matter to the DPP, the Director of Public Prosecution. Let me read that again. That the code of conduct for persons in public life, if they are considered to have breached this conduct, they may be reported to, they are subject, let's put it that way, subject to disciplinary action by the PSC, the Public Service Commission, or the Commission, the Integrity Commission may report the matter to this Director of Public Prosecution. Now, where the Director of Public Prosecutions is satisfied on the examination of a matter referred to in subsection 2 and other relevant evidence that any person in public life ought to be prosecuted for an offense under section 32 of the ordinance, he or she shall undertake criminal proceedings against the person in public life. It's a very serious thing. That where the DPP is satisfied upon examination of a matter referred to, that any person in public life ought to be prosecuted for an offense, he or she shall institute and undertake criminal proceedings. Acceptance of gifts. In my last life as a worker, spent all these years in that profession, the acceptance of gifts is a very serious thing, and the code of conduct speaks to acceptance of gifts, and it says that a person in public life shall not demand the gifts, favors, hospitality, or any other benefit for himself or herself, or his or her family, close relatives and friends, or persons or organizations with whom he or she has or had business or political relations, which may appear to influence the impartiality with which he or she carries out his or her duties or may be or appear as a reward relating to his or her duties. What this is saying is that a person in public life is asked to stay clear of accepting gifts, and the section used the word demand gifts. It went on to say that it goes on to say that it does not include conventional hospitality or minor gifts. But where a person in public life is in doubt whether he or she can accept a gift or hospitality, he or she shall seek the advice of the Commission. Let me say that again. That where a person in public life is in doubt as to whether he or she can accept a gift, he or she should feel free to seek advice of the Commission. And finally, any person in public life who fails to comply commits an offense with the acceptance of gifts, commits an offense, and is liable on summary conviction to a fine equal to the value of the gift involved in the commission of the offense, or $7,500, whichever is greater. Let me just read that again, and this is the final note. That any person in public life who fails to comply with the accepting of a gift commits an offense and is liable on summary conviction to a fine equal to the value of the gift involved in the commission of the offense, or $7,500, whichever is greater.
Thank you, Commissioner Tyrrell. I would just like to bring to the general public the part 5 that deals with the financial provisions. And basically what this section says is that the funds of the Commission shall consist of funds as may from time to time be placed at its disposal by the Nevis Island Assembly, and other monies as may be lawfully paid to the Commission for the purpose of this ordinance. That is basically money for us to function as a Commission. The Commission is tasked that it shall keep proper accounts of receipts, payments, assets and liabilities, and those accounts shall be audited annually by the Director of Audit or such other auditor appointed by the Deputy Governor General for that purpose. We are obligated by the ordinance that the Commission shall in each year and not later than 31st January prepare and forward to the Minister, and that is the Minister of Finance, a report of its activities during the previous financial year, including a statement of its accounts audited in accordance with Section 37. A copy of the report together with the auditor's report shall be laid before the Nevis Island Assembly. The Commission shall, on or before the 15th day of September of each year, submit to the Minister for Finance for approval its estimates of expenditures in respect of the next financial year, and which we have already done, so we are waiting to see what funds will be allocated to us. Also, for the general public to be aware, when the ordinance was enacted in 2013, there's a list of persons who are subject to the ordinance, which we would call the persons in public life. And I will just go to that list, because then there was an amendment so that persons can be aware as to what changes were effected. So in 2013, when the ordinance was enacted, the list of persons who were subject to the ordinance were members of the Nevis Island Assembly, ministers of government, president of the Nevis Island Assembly, parliamentary secretaries, permanent secretaries, heads of department in government ministries, legal advisor, and legal officers employed in the public service above the level of grade N40, chairman and board members of any public institution established by or under any ordinance of the Nevis Island Assembly, so that would be NEVLEC, NASPA. Directors and managers of majority government owned or controlled banks or other financial institutions or statutory corporations or companies, such as the Nevis Cultural Foundation, because that is a statutory corporation. Chairpersons and executive members of political parties, advisors to the administration. When we started our first rollout with respect to persons filing declarations, there was a bit of a hue and a ha, and at some point in time, the Nevis Island Assembly deemed it necessary to go to Parliament and to amend Schedule 1. And so on the 19th of November 2019, an amendment was passed, and that amendment basically amended Schedule 1. And so the new Schedule 1 that now falls under the ordinance, and the persons who are now part of public life are President of the Nevis Island Assembly, members of the Nevis Island Assembly, ministers of government, members of cabinet, parliamentary secretaries, legal advisor, permanent secretaries, legal officers employed in the public service above the level of grade N40, heads of departments and directors employed in the public service above the level of grade N40, chairman and managers of majority government owned or controlled banks or other financial institutions or statutory corporations or companies. And the legislation further states, this schedule shall, for all purposes, be treated as coming into force on the 20th day of June 2018. So what that basically means to the persons out there listening is that what the Nevis Island Assembly did when it amended the schedule, it took out directors of majority government owned or controlled banks, and it also took out board members of any public institution established by or under the ordinance. It also excluded advisors to the administration, and it also excluded chairpersons and executive members of political parties. And what it did by that simple sentence was that it made the removal of all these persons retroactive to the date when they would have begun filing, when we started our first filing of declarations, which would have been the 20th day of June 2018. And so we have sought to give you in a nutshell the ordinance, the bits and pieces that come together to make up the Integrity in Public Life Ordinance, which we as the Commission seek to implement as we go forward, trying to implement the ordinance as mandated by law. Thank you.
Okay, yes, Mr. Keynes, very well. We've gotten an overview of the content of the Integrity in Public Life Ordinance. We'll take a break and we'll come right back. This is Thought That Get Results with Mr. Ricardo Keynes. He is the chairman of the Integrity in Public Life Commission. Mr. Sidney Newton is a commissioner, and Mr. Alfred Tyrrell is also a commissioner. So we'll be back after
these. Is offering a large variety of floor and wall tiles at very competitive prices. Builders Paradise has over 2 million pieces in stock, lots of different styles to choose from. Whether you're renovating or tiling a new house, Builders Paradise has what you need. Wow! Oh, and remember, we're open all day Saturday to serve you better. This is something that you can't refuse. Visit Builders Paradise today at the C.A. Paul Southwell Industrial Site in St. Kitts, or call them at 466-4938.
When
and vibrate. The whole Caribbean must shake.
860 AM, the Powerhouse.
Back on this episode of Talk That Get Results, the Integrity in Public Life Commission Ordinance. That is what we're discussing here with the chairman of the commission, Mr. Ricardo Keynes. Alfred Tyrrell is a commissioner, and Sidney Newton is a commissioner on that commission as well. We've just heard an overview of what the ordinance is all about. Mr. Keynes and Mr. Tyrrell and Mr. Newton, again, thank you for being with us here this evening. Callers, your participation is on 1-869-469-1616 and 01700. Now, I get it in terms of the legal language and the ordinance and all that. Put it in layman terms. What is this ordinance simply seeking to do as far as persons in public life are concerned? And before we do that, can we determine what do we mean by persons in public life? Does it apply to persons who work in government institutions or work for the government?
Well, yes, the legislation basically applies to, in a nutshell, it applies to a list of persons who work in government, for government, well, for the people of Nevis, and also statutory bodies which are basically owned by the people of Nevis through government.
But it never pre-2000 and what it is, 13.
13, yes.
We did not have this ordinance.
No. Pre-2013, I believe there was always the, well, if one look back historically, there was always the talk between the various government that, you know, they would seek to bring legislation in place to govern ministers of government and senior civil servants because of the constant accusations of corruption, bribery, theft, as the case may be. So in 2013, both on St. Kitts and on Nevis, each island enacted integrity in public life legislation. So you do have federal legislation on St. Kitts that governs federal employees of the federal government, and we do have the ordinance on Nevis which governs persons who work for the Nevis Island administration, the executive, which comprises the premier, his cabinet, the persons who comprise the Nevis Island Assembly, and senior civil servants. And senior civil servants, based on the schedule, comprises persons who are basically permanent secretaries, parliamentary secretaries, legal advisor, legal officers above the level of grade N40, and heads of department and directors employed in the public service above the level of grade N40. Initially, in 2013, you had directors and board members of these statutory corporations being captured by the ordinance. But the Nevis Island Assembly, in its wisdom, went into Parliament and enacted a new schedule and basically removed directors and board members. And so it left chairmen and managers of majority government-owned or controlled banks or statutory corporations.
So in essence, this body of rules or guidance is geared towards addressing, as you indicated, some of the accusations and so on that we used to hear in talk shows, for instance, and suspicions that the general public had in reference to the behavior of public officials?
Yes. In that, yes, in a way, it seeks to kind of, how should I say, deal with that situation. So, in effect, these persons who are in Schedule 1, annually they will file their declaration, and the declaration basically, it's a couple pages long, and they would have to set out all their assets and liabilities. It comes into the commission, it is documented. We have staff who goes through, and then we as commissioners will then look into each declaration that is filed by each person. We can then compare and contrast from, let's say, if you file in 2019, we can look at your 2019 filings, we can look at your 2020 filing and see if there are any anomalies. We can also do our own investigation under the ordinance. If we see any anomalies inside there, we can bring you in and we can, question you, ask you for additional information.
So pre this ordinance, there was nothing formally that can basically address those situations you're saying?
Not in a, how should I say, not in a holistic way. You would have had other legislation that is out there that if, say, a person felt that, say, let's say PSA basically was taking a bribe or doing anything underhanded, the individual would have to basically gather that information and give it to the police and hope that the police will then do an investigation into that person. And based on the investigation from the police or the white collar crime unit, then charges could be laid against the person. Now, by having the commission and, let's say, Permanent Secretary A, he now filed his declaration with us. He has stated these are his assets, these are his liabilities, these are his blind trust that he may have signing authority over. We get that information. We will then seek to do what we have to do in terms of investigating to ensure that what he or she has filed with us is truthful. Now, the ordinance states that if you lie on the form by inadvertently leaving out any information and it comes to light that you do have other assets that you did not disclose, then that asset can be forfeited to the Crown. So in a way, the declaration sought to basically bring all the information in one space that it can be looked at and then kept, and over time it can be, compare and contrast to see the assets that have been moving between, let's say, Permanent Secretary A over a period of time.
So whether or not there was any undue additions
or subtractions
in a particular period of time.
Yes.
So to keep with your hypothetical with Permanent Secretary A, and they file and they said, for instance, they had $1 million in assets and they listed them, and you're saying then that a member from the public gets onto the commission and says Permanent Secretary A has now, in the space of 6 months, we understand, blossomed out heavily in terms of his assets. You're suggesting that the commission can take that information and then look at it?
Yes, I would say yes, based on the ordinance, because one of our duties is to look into corruption and bribery. And so in order for us to look into corruption and bribery, it would mean then that persons in the general public should be able to provide the commission with information. Now also, as the commissioners, we will bring a level of, integrity, and we will look at the information that is presented to us. It doesn't mean that we're going to go off on what we would call a safari, just go willy-nilly because someone presents information, but you would sift it. You'll be able to look. You would also try to employ methods and procedures that you can then investigate off your own. Well, the commission can investigate off its own to verify the information that Permanent Secretary A provided. Because one may say, well, he would have sworn an oath when he provided the declaration that everything that he has given to us is truthful to the best of his knowledge. But if we then in our investigations find out that he has withheld information from the commission, we can then investigate. I can't really say what we will do, how we go about the procedures, but there are ways and means of trying to find out, what assets are being hidden by persons out there.
It puts, hypothetical, it creates something that's very interesting, though. Is the commission obligated to act on information that is given by the public? Because what if someone argues that member of the public, a particular member of the public, is biased against a particular permanent secretary A, and therefore makes up information and then gives it to the commission?
Yes, and we have been, yes, and that has come to our attention in terms of when we have had our sessions with members who are affected by the legislation that has been put forward to the commission. And what I can say to persons is that the fact that you have 3 persons on the body who, based on the ordinance, will bring a level of integrity, impartiality, and also sound judgment and diligence and competence, capable of exercising competence to their work, we would be able to sift through whatever information is provided to us. We know, yes, we're in a small society, and persons, yes, you can't help but hear things here or there. But we can only look at what is in front of us. We have declarations that are filed. We have the power under the ordinance to reach out to the financial institutions to see what accounts and what the account who is held by, let's say, our hypothetical permanent secretary A. Once we have that information, if someone provides us with additional information, we can sift it and we can see what truth there is to it, and from there we'll then be able to know how we go forward. So you do not want to say to the public, well, you know something but you can't tell us anything, and if you tell us, we just simply take it and we run with it. It's an exercise that one has to go through.
Mr. Keynes,
in sifting.
Let me take this our first caller. Good evening, thank you for holding. Mr. Keynes, good evening, thank you for holding.
Good evening.
Callers, we're going to ask you please to listen to the telephone and not, you know.
Good evening, and good evening to the committee.
Caller, you want to please turn your radio down and listen to the telephone.
Caller, you want to please turn your radio down. Yes.
Yes, go ahead, please.
Good evening.
Good evening.
Good evening.
Hello.
Yes, we're hearing you.
Yes, go ahead, please. Good evening. Yes, we're hearing you. Yes. I tried to comment or find out whether or not the commission might have made an error in excluding a director and including a manager in the penalty aspect of the commission's work. What in the legislation or the wisdom of the Nevis Island administration or assembly in drafting that legislation and have excluded a director of a public facility, public government facility, and included a manager? Am I clear?
Yes, you are. Well, what I would say to thanks for your call, caller. What I would say, in answering your question or your comment is that we have no, as the commissioners, we have no control over what amendments the executive, that is the government, and the Parliament, the Nevis Island Assembly, makes to the ordinance. They, in their wisdom, decided to remove directors and board members out of the ordinance, but they left in managers when they did the amendment. From our understanding, I think persons who were caught initially with the first set of filings that they had to be done, many of them were objecting to having to file because they were directors and they felt maybe the compensation that they were getting was not enough worth the effort to file, and so persons would have made, I assume, they would have entreated, they would have spoken to their parliamentary representatives, and their parliamentary representatives would have made the decision to go to Parliament and remove them, or that body of persons, from the ordinance, and that was done. And yes, we do have managers captured in the ordinance, and I can say currently we do have persons who are managers, but they refuse to file on the basis that, as far as they're concerned, they do not handle any money, and so because they do not handle any money, they should not be captured by the ordinance, or we as the commissioners should have a discretion as to say who is a manager, who isn't a manager, and which manager should file and which manager should not file. And when we had our session with persons who are under the purview of the ordinance, we were at pains to indicate to persons that as commissioners, we do not sit on the board of any of the government statutory bodies, so we do not know how these corporations allocate their, how should I say, their duties among their members, who is called a manager and for what reason, and why another person is not called a manager. That is an internal matter within the organization. Once we have the information from the statutory body that says this is the list of the chairman or chairperson, and this is the list of managers, we're then obligated by the ordinance to send out the declarations for filings. And there are a lot of persons who refuse to file, and at some point in time the commission will have to go to court for the court to then determine whether or not these persons are captured, and if they should file, and if, since they haven't filed, what will be the consequence of them not filing. But in order for us to do that, we need money in order to be able to go to court, and we have asked the government for a subvention of funds so that we can go and test the ordinance in the court to say, who is a manager and who isn't.
Do we get the sense, Mr. Keynes, that by and large persons who fall under the caption or the description of the persons who should file, do you get the sense that there's a high percentage of persons who do not feel that they should?
Well, I would say when we started out, when we did the first set of declarations were filed in 2019, if I'm not mistaken, we had, one could almost say, almost 98% filings. Then in 2020, that number fell down a bit. But by then, the amendment was done, and that basically took out a large group of persons who would have complied in 2019. When the amendment was done later down in the year, it took them out. And so in 2020, that number was reduced of persons who had to file, and we still had a good percentage. For filings that has to be done for 2021, from my understanding, I think we now have about a 35.80% returning of declarations. So the numbers are very low for this year. From what I understand, with respect to, let's say, like heads of departments, if government has, let's say, if there's an average of 24 heads of departments, only 8 of them have filed. So it means there's a large number of persons out there who have not filed. If we look at principal assistant secretaries, if 7 of them are to file, out of that 7, only 4 has filed. Let's say if we look at permanent secretaries, there are 9. Out of the 9, only 4 has filed. And I would say some of them, I guess, have felt that they don't even wish to even write to the commission to ask for an extension of time. They just decide not to file on time or file at all. And so that is where we're at this stage of the process.
Is that number therefore not consistent with general practice in adherence to rules in the society?
Well, in some sense, yes, and in some sense, no. I think when in the last 2 years when filings were done, as I said, the rate was high. However, I think what has happened is that when we've had our meetings with persons within who are affected by the legislation, it's been very combative in some instances, and there are some persons who just feel that they will not file. They were told not to file because, in their view, again, in their interpretation of the ordinance, they may be a manager, they may have the name based on the in the government statutory body that they work for, but as far as they're concerned, they don't handle any cash, so therefore I'm not filing, or I was told not to file.
But in my read through of the ordinance, and I didn't read it maybe as closely as you may have done, but I didn't get the sense that one of the criteria was that you have to be handling monies.
That is true, exactly, and that is what we have been at pains to tell persons, that handling money has absolutely nothing to do with it, but they are of the view that they spoke to persons other than us in their minds who are in different positions within the system, and they have been told they don't have to file, don't worry about it, or whatever the case may be, and they have decided not to file.
You think, though, that maybe this ordinance, in reference to the way the society is a bit early?
No, I don't think it's a bit early, because the same society, on one hand, over the years, we all live in this society. Over the years, they have made accusations against persons about bribery, corruption, the whole 9 yards, and so you can't on one hand keep throwing that stone and those accusations at persons, and now that an ordinance is in place so that those persons can comply to show that, well, look, I am doing what I do above board, my assets are acquired in the normal course of my duties.
But you see, I do a lot of this stuff and hear a lot of this stuff, as you know, and I question very seriously whether or not it is not normal rhetoric that is used at a particular period of time, and people don't really want to go beyond that. For instance, I know there are instances where I know Mr. Newton, even when he was back in the agriculture department, remember that, Mr. Newton?
Yes, sir.
And we had the issue with roaming animals. And the remedy will always be, the excuse is that we need certain laws in order to be able to deal with them.
Yes.
And so they will put the laws in. And then some other officers who were unaware that the laws were in, when the topic of the discussion comes up, they use that as the excuse. And when they find out that the laws are in, then they hush. Because it wasn't really an intent to really do anything about it, but it's just to have the conversation and so on. That is somewhat part of the reality, isn't it?
Yes, that is true. And also St. Kitts and Nevis has signed on to a lot of conventions against, at the United Nations against corruption. We go out there and we preach to say, we are part of the worldwide body, and being part of these bodies mean that you also have to put in domestic legislation laws against corruption and bribery, that is more specific. And I think maybe we're a bit late in coming to this arrangement, because when we look at the other Caribbean islands, Dominica, Antigua, I think the Integrity Commission in Grenada, they have been around far longer than us.
Right, but we put the laws in, and to come back to the example with the roaming animals, etc., we have the laws in.
But we do not
but we don't do anything about it, because they were not meant to do anything about it.
That is true, yes.
So, is it possible then that we put this Integrity in Public Life Ordinance in, but
unfortunately, I would say then we got appointed, we were given a budget, and we hired staff, and we are doing what the ordinance requires us to do.
Right, but and the level and the part now of the persons, because here is where we're at now.
Yes.
With the public at large, right? Now you're indicating, based on the evidence and the statistics, the numbers, you're getting a heavy pushback.
Yes, we are.
Because the society is basically saying that we don't want to operate that way. Now we get it that as part of this conventions we sign on and so on, so to theoretically put us in a particular place.
Yes, I agree.
You know, Mr. Herbert, when we were appointed, that was never indicated to us. We got the impression that this is serious business and they want to get something, you know, working that holds public officials accountable. We were not involved in the legislation writing, so our function really is enforcement, implementation enforcement.
Okay, Mr. Newton, let me take this. Good evening, thank you for holding. Good evening, you're on the air.
Let me take this. Good evening, thank you for holding. Yes, good evening again. Trying to find out. Good evening, you're on the air. Yes, the list of assets that the commissioners had. I'm not sure if I heard intellectual property and paintings, as the case might be. So, can they go through that list again, please? Quickly.
Well, the list is basically a list that is in the ordinance itself. It's a schedule in the ordinance that basically lists the assets that you have to disclose to the commission. I'm just trying to get that list. It's comprehensive, but as you may say, in terms of intellectual property, I think it may be captured under some aspect of it, but I'm not. Well, it could be considered let me see here. Quickly.
Section 12.
Section 12. Immovable monies, values, insurance. Well, it can be considered under any other property owned by a declarant, and that would mean intellectual property, anything that is not normally captured in the house, land, and stuff of that nature. I would say that this legislation passed in 2013, the federal legislation that was passed in 2013 also. We have, over time, the commissioners and I, we have sat down and we have looked at other jurisdictions to see how we can improve upon our ordinance in terms of amendments, and we're hoping that at some point in time we'll be able to put some stuff in place, amendments in place, and have that sent to the executive for them to look at and hopefully amend the ordinance so that we can, bring it more up to date.
But we're not getting the corporation, Mr. Keynes. Good evening, thank you for holding. Good evening, hello, you're on the air.
Yes, a very pleasant good evening, Webbo, and your panelists here. Good evening.
Good evening, sir.
Yes, I'm on here. Webbo? Yes.
Your callers, what I would like you all to do is you come to your telephone, turn off your radio, because you'll hear it on the phone. Okay, go ahead.
Yeah, my radio is turned on.
Off, turn it off.
Hello?
Yes, go ahead, please.
Hello, Webbo?
Yes, go ahead.
Off, turn it off.
It's off.
Yes, go ahead, please.
Yeah, okay.
Yes, go ahead.
Yeah, no, wait. I have a question. Now, if a civil servant is assigned to a job and that civil servant hasn't been working on that job, he hasn't been shut from the treasury every month, even though he's not working, can a case be brought to that individual? I will listen after you, so I could turn on the radio.
Did you get a question?
Yes.
Okay, go ahead. Yes, thank you, caller.
Yeah, okay, all right, thank you.
I thank you for your call, caller, but we as a commission would not be able to look into a matter of that nature. If a civil servant is assigned to a job and is basically not showing up to do that job, there is a process in place where the head of that department or the supervisor of that civil servant should, prepare the requisite information and move it along the lines up to I would assume, to the permanent secretary, Mr. Newton, and then from there on to the Public Service Commission for them to be dealt with.
Right.
Our role is to deal with a particular set of persons in public life with respect to declarations of their assets and liabilities on a yearly basis.
In looking
And
through,
income.
In looking through this ordinance, I noticed it was fairly involved in terms of the practices of civil servants. And I wanted to ask whether or not you were also in concert with the what you just referred to, with where the Public Service Commission deals with, and whether or not there was any overlap or conflict. Because I know with certain things in terms of the behavior of civil servants, the Public Service Commission normally address those issues. So I was wondering whether or not you have found any examples or instances in terms of the dictates of the rules or the laws where you may have an overlap.
Well, what we found, Webbo, is that there were persons who questioned whether or not the ordinance has effect over the public servants' functioning, because they said that in some instances there is conflict with the Public Service Commission. That would have been a matter for the executive to iron out with the Public Service Commission, or between the two commissions. But the commission on which we sit is clear in its role, what it ought to do and how it will go about doing it. And we work through the permanent secretaries relevant to us, Premier's Ministry, Finance, Human Resources. And we know that the Human Resources Permanent Secretary is the one who is in contact with the Public Service Commission, so that wherever there is any discrepancy in thoughts, ideas, construct, we try to get them ironed out at that level. We do not have any interaction directly with the Public Service Commission.
Under general principles and the code of conduct under your ordinance, page 23 and section, the third paragraph, it says a person in public life should act in a politically neutral manner and should not attempt to frustrate the lawful policies, decisions, or citations of a public authority. But number 2 says a person in public life should carry out his or her duties in accordance with law and with lawful instructions and ethical standards which relate to his or her functions. Now the one with the politically neutral manner and stuff like that, that is interesting also, because it seemed to suggest that a person in public life should not act in a manner that somebody can dictate which political party he or she supports. On the contrary, right? One will argue that the Constitution gives the person the right to express his views and opinions nonetheless. So some of these, I find are very interesting. And then whether or not these are things that are not also in the code of conduct which the civil service deals with. And that's why I asked earlier whether or not you find some of these functions are overlapping. And then it comes out back to the question again, Mr. Keynes, and maybe you and I hearing after this program might have a debate on it, whether or not how much of it was really meant to put into practice. Good evening, thank you for holding.
Good evening. The person who declares the asset, the person in public life, do they have to declare their family assets, their children assets, or just their assets.
Thanks, caller. The person in public life would declare their assets and also any child that is under the age of 18, or let me just get the section. Right, a child under the age who has not attained the age of 18 years and is not married, or having attained that age is under the age of 25 and not married and is pursuing a course of higher education, and includes a stepchild or an adopted child, and in respect of a man includes a child born of wedlock, of whom the man had been adjudged the father by a court of competent jurisdiction, or whom the man had acknowledged to be his own child. So once that person falls within the definition of child, then you also have to disclose any assets that that child may have, because we know that, you know, I mean, one of the things when it comes to hiding assets, persons will hide assets through their children. They would hide assets to what we call blind trust. That is where they basically pack their assets into somebody else to hold for them while saying that, well, I don't own anything. And so the law tries to capture those areas, because not repeating the wheel, but persons have done it in the past, and so the ordinance sought to capture those persons who would seek to evade the ordinance by saying, well, I own nothing, but we know that their assets are hidden into third parties.
Under this ordinance, let's see whether or not I have it correctly. It seems to suggest, using a hypothetical, if I work in public life, let's say the manager of one of the corporations for the government, for instance, and I'm captured under that, right?
Yes.
Right. Okay, fine. And it seem to suggest that I should not have a private business operating at the same time, correct?
No. It is not saying that. All the ordinance is saying is that you disclose.
Disclose it.
Disclose it.
Good evening. Thank you for holding.
Good evening, very well.
You're on the air. Could you go ahead?
Yes. I think I have a few questions. I must say first that I sort of detected a bit of a frustration from Mr. King when he spoke about limitations on his subvention or budget line in order to deal with legal matters and members taking action against persons who should be filing. Am I correctly hearing that? That is one. Two, in terms of filing, what is the status of members of parliament as we speak? Are they in good standing, unlike others you mentioned earlier, low down the rank? Another point is the way we have conventions with other jurisdictions, or to be like on the United Nations, and relationships, reciprocal relationships like the U.S., Canada, and so forth, like on tax matters. Do we have that relationship with respect to our public life integrity here matters that we can be asked to submit to other jurisdictions, and we can request information from those jurisdictions as well? I will listen off here. Thanks.
Okay, thank you. Yes.
Thanks, caller. Well, with the first question, well, I would not say that the commission is frustrated. We're just seeking to just let persons know that, well, we have requested, budgetary subvention so that we can basically do what we need to do as mandated by the ordinance, and so we're just waiting for those funds to come, and once those funds come, we will seek to then move the matters to the court so that the court can then determine the argument as to who is a manager, who is not, and whether or not they have to file, and and those who decide that they're not going to file, the court can then take the necessary action to force them to file.
Do you get the impression that persons do not want to file just because they don't want to be a part of the process, or because they think that they can, how should I put it diplomatically? They fall under the heading of persons who will in the end be investigated?
That's interesting. I'm not sure if they would fall under somebody who would be investigated. I think from the feedback one gets, some of them just think that they should not file, because it comes back to their notion of what they deem a manager is supposed to be. For example, somebody may be, let's say, someone might be CFO of, let's use a statutory corporation, let's say Nevlec. Someone might be a CFO of Nevlec, and as far as they're concerned, well, I'm the chief financial officer, but I'm not a manager. So therefore, should I file? Because the ordinance does not say chief financial officer.
But let me ask you this.
Mr. Newton could then elaborate as to what in his institution a chief financial officer does. I mean, one would think that he's a manager, but then again, I don't know. I mean, it begs the question of the interpretation.
But let me ask this. If, in the opinion and interpretation of the Commission, you fall under that, does the Commission have instructions via the ordinance to, if you do not comply, then move to do A or B?
Yes.
So why is the Commission not doing that?
Well, we have done A in terms of publication in for persons who did not file in 2019 or 2020. We will again, once the time period has run out, we will publish for persons who have refused to file for this filing period also. So we can do A. Then the next stage is B, which is to then go to the court to seek declarations and fines for persons who have not filed. But in order for us to do that, our budget as it now stands, we need the money from the executive in order to be able to take that step forward. And so we have requested the subvention that is necessary for us to start the process. But until the money hits our bank account so that we can then retain counsel or counsels to do the work on our behalf, we would be basically in a holding pattern, because the government has a legal department, but the legal department of the government is basically there to defend matters with respect to the NIA and not the Integrity Commission. Because though we are, though we are a creature of the Nevis Island Assembly and we get our budgeting from the government, we cannot rely upon the government legal department to then do matters for us, because the same legal department lawyers will then be also under our purview with respect to their filings.
Does what responsibility does the Commission have to investigate claims that are made by members of the public? In other words, if I were to write or come to the Commission and say, person A in a particular position in government is taking bribes or using their position for undue gain and so on and so forth, what obligation does the Commission have to investigate my claim?
We have an obligation. The legislation says we are to deal with bribery and corruption, and so
alleged stuff,
right? So
once people can just suppose they don't like it.
No, but again, once the persons come in, and whether they write or they come in and they bring the information, we will then assess and sift it, and basically we will then know where to go with the information.
Does the person have to
not go with the information?
Does the person have to bring the information on the record? In other words, if I bring it, can I bring it anonymously, for instance?
You can bring it anonymously, but I would also ask that you also ensure that you have documentation, because documentation is important. Trust but verify is an important thing.
So a person with an allegation with no facts or anything and stuff like that, that's something that the Commission will not follow?
Well, we will read the allegation, or we will hear the allegation, whichever case it may be, But again, as I say, we cannot just say that we will dismiss outright.
But if the person doesn't bring the information, Mr. Keynes, is the commission duty bound to do the investigation? That's what I'm saying.
No, it's not duty bound to do the investigation.
Yes.
But in all things, everything is nuanced, and so you let things come in, and then you sift it as you go forward.
You think perhaps when we get going, we may have cases where people might argue, well, you investigate A and the society is small. How come they're not investigating B?
Again, the investigation, again, we have the declaration of the persons who are affected by the ordinance. So I have to make it clear that it is not the ordinance, the way it is structured in Schedule 1. If initially we had, let's say, 100 or let's say 110 persons who were captured by the ordinance, that number was then cut down to
60.
maybe let's say 60 persons. So therein you have removed a whole swath of persons.
If a person is not captured by the ordinance and they're in a particular area in government,
Right.
but some hard evidence comes to the commission, this person is in public life nonetheless, but they are acting in a manner that is corrupting the system. The commission does what?
We cannot, basically based on the ordinance, because they are not subject to the ordinance in the filing of declarations. Basically that information would have to then go to another body such as the police or the white collar crime unit for them to investigate that side of the allegation. Because as I said, initially we were, a swath of persons were in, and then that number was reduced. And so those persons who were in some of them have been removed. So legally we have no obligation. They have no obligation to file. We cannot compel them to file.
So in effect, we have an ordinance which, notwithstanding 100 people, has the potential and the ability, because of their position, to corrupt the system. 50 comes under the ordinance and the other 50 does not.
Yes, that is so. Mr. Tyrrell, if you want to.
Yes, Mr. Tyrrell.
Yeah, no, I'm smiling because I think Mr. Herbert is wondering some stuff. Yeah, but if that 50, Mr. Herbert, is not captured, but the
Yes.
evidence, like the chairman said, that's a police matter, that's not us.
Right. Well, right. So the point is that it is not you, but prior pre-2013, the entire 100 were police matters. You agree with that?
Yes.
Yes.
So you take 50 from being police matters and you put them under a commission,
Yes.
and the other 50 remain police matters.
Unfortunately.
Well, I mean, what I would say, when we look at the federal legislation in St. Kitts, I believe, I think the way their legislation is structured is almost up to 1,000 persons, I believe, that will be captured. When it comes to filings, if and when the legislation in St. Kitts is implemented. I know there's a commission that is established in St. Kitts. It is being funded. It is being staffed. Justice Pauletta Lance, she's the chair of that commission. So they are there, and they are now pulling them, doing what they need to do to be able to then, go out there and start, getting declarations filed as the case may be. But yes, they have a wider swath, whereas we, who originally started out, let's say, with 120 or 110, then we were then cut down to just 60 persons or thereabout. And I think the gentleman had asked the question as to the filings, I believe, for the assembly. What I would say is that yes, the assembly, we have had most of the persons in assembly have filed, but then one also has to look that when it comes to the Nevis Island Assembly, the assembly overlaps with the executive, because that is how our system is, in that our assembly is not just by itself. Members of the assembly also makes up the government or the executive, and so there is where you have an overlapping.
Right, but there are some persons who are in the assembly but not in the executive.
Yes, so those who are in the assembly and not in the executive have filed, and there are some of them who are in the executive and in the assembly have not filed.
Well, it would be interesting, as we say, going forward to actually see the functioning of this particular commission and ordinance, because as we've just pointed out, that hitherto there were these breaches or possible breaches would have been handled anyway by the police authorities or some other authority.
Yes.
Allegedly the acts were being committed, but nothing was being done. So it will be interesting to see going forward whether or not, and then overall as a society, whether or not the allegations cease or it just continues to be a normal rhetoric around a certain time.
That is true. Yeah, but go ahead.
Yeah, but one of the callers asked a question about relationship with other jurisdictions, and I think it is important for the public to know that the commission in St. Kitts and Nevis have recently joined the Caribbean Association of Integrity Commissions and Anti-Corruption Bodies, and we interact via conferences and other means of communication with our fellow commissioners across the Caribbean, from the Turks and Caicos Islands, Jamaica, Bahamas, right down to Grenada and Trinidad and Tobago. And Guyana. So that these issues that we are discussing now are often discussed at these conferences. And what we found to be common is that it seems that most commissions have the same problems or similar problems. However, some are more advanced and they have been able to function and be effective. And so what we are doing tonight is part of the public education, which the Commission thinks is important for the public to understand the role of the Commission, which many countries have formalized. They have gone beyond just a radio talk show, and they have gone into the schools and are educating the children, so that people will grow up with a new culture of decency and integrity, so that when they get to the stage of becoming public officials, they will understand how they ought to conduct themselves.
Yes, and also
sorry.
Go ahead, Commissioner.
Yeah, and to follow up on Commissioner Newton, I'd just like to add that our chairman now was elected last AGM to the executive of the Commonwealth Caribbean Association. So we sit at the table.
And also, not only myself, but also Justice Lance was also elected as part of the executive of the CIBC committee. And also just so that the public is aware, also we here in Nevis as commissioners, we try to meet with our counterparts on St. Kitts, so that we can discuss, common issues, see how we can deal with, common problems, see where we can get best practices. And I want persons out there to understand that at the end of the day, these commissions are not to be feared. It's not that we as a body is coming out there to know your business and to, want to basically, how should I put it,
look news,
as as the local parlance would go. the system is basically saying that all that is happening is that we are just hoping, as Mr. Newton, as Commissioner Newton has said, is to just bring a new sense of awareness. This has been happening in other jurisdictions: Turks and Caicos, Cayman Islands, Guyana, Trinidad, Grenada. It's just that for Nevis, we are a bit more limited in scope compared to some of the other jurisdictions that we interact with. But the intention is to ask public servants at whatever level that while you're there, you're serving the public, that you do it with a level of grace and integrity, so that when you leave and others come behind, you know, it continues. And yes, there's always going to be the allegation of theft and corruption, but if you're not doing anything wrong, you have nothing to hide, you present your declaration, you present your information, and all is well. And all we're asking you to do when you're filing your declaration is to be truthful and honest. Put the information there, because if we then go and we find out, then you know you're in a whole different world of issues that can be avoided by just simply putting down the information. If you don't know how to fill out the form, we have someone at the office who is able to assist you. We have done we have formats where when we send out the declaration, we send out the format as to assist persons how to do the filings, so that at the end of the day you can do a proper declaration, the commission can be happy, and then we can know, after investigating everything, we can issue you with your certificate to say that yes, you have complied with everything, and for 2021 or 2020, everything is good.
All you're asking, Mr. Keynes, sounds simple, but is it a big ask?
No, it's not a big ask.
I don't.
It's not a big ask.
Good evening, thank you for holding.
Webbo, good evening once more. Something else came to mind quickly. It has to do with if someone who filed feel that there's something egregious was done to them by the commissioner, do they have any recourse through this ordinance or any adjoining ordinance or any law ordinance of the state that can protect them the way that person is made call upon to be fined and penalties apply, like $50,000 fine and 5 years imprisonment? Is there any recourse one can have against the commissioner? Right.
Yes, caller. One, if we as commissioners disclose your business or your information without a proper court order, we can be fined we can be fined $50,000, be removed from the be removed as a commissioner, and also face time in prison if our staff disclose information of any declarant to any third party that was not authorized by a court order. That officer would be fired and also would face a fine of $50,000 and also imprisonment. So yes, there are mechanisms in place to ensure that what your information that you give to us is held in the strictest of confidence.
Good evening, thank you for holding.
Good evening, gentlemen. I just wondered if the Commission can advocate for the strengthening of its hand, giving it more teeth, let's say in terms of making sure that there is whistleblower protection, for instance, and that there is some kind of way that they can be independent totally, even of the funding, something like, let's say, the court, of the executive arm, who they, after all, are going to be, maybe may have to investigate, right? And don't you think that an accompanying legislation like freedom of information would help the Commission in its work? And finally, there are arms in the government that you seem to, it seems that you're going to have to depend on, like perhaps the police and the financial intelligence unit and those arms of government that are not under your control, okay? And so your work can be thwarted.
So I'd like your opinion on these things. And by the way, right, I don't think it's enough for a commission to just sit there and look at the declaration. It gives the appearance of just another bureaucracy tucked away somewhere, and the public does not see the commission doing its work. Is there any way that, for instance, the commission can lay before Parliament some kind of report? You know, because who will the commission be answering to? that in the final analysis, who does the commission answer to? And it should not be to those who they may have to investigate. Okay.
Okay, thank you. Put another way, also, Mr. Keynes was about to ask you, at this stage of the process, the development of what you're doing, what influence or authority does the political directorate have?
Okay. Well, basically, under the ordinance, we are supposed to write a report and have our accounts audited and presented to the Minister of Finance, who is then supposed to lay it in Parliament. So that, from what the caller is saying, yes, the Minister of Finance is the one who lays the report in Parliament, but we do not have, the legislation does not give us any authority to bypass the minister and have the report sent directly to the president, and then the legislation forces the president of the parliament to then present it to the entire body. So it all depends on the minister, once he gets the report, to do what is necessary by legislation. Two, in terms of funding, yes, we get our monies from government. How can one bypass that? That's an impossibility. At the end of the day, the public elects the executive, and by virtue of electing the executive then determines how the public purse is disbursed among all the competing interests that they deem necessary in the country. And so all that we can do is advocate that when we submit our budget, that we will get the funding that is necessary for us to do what we need to do, and not be, as the caller says, another level of bureaucracy just tucked away in a corner in the system.
Freedom of Information.
Freedom of Information Act. Yes, I believe we do have legislation in St. Nevis. However, we have no power over having the powers that be to basically have the legislation gazetted and implemented. We all are aware, and I mean, as a lawyer, we know too well that the executive will go to Parliament and pass legislation. They'll make a song and dance of it so that the public gets the impression that something has been done. But then there's a little clause inside there that says the legislation shall only come into effect upon a date given by the minister by virtue of the Gazette. And for whatever reason, somehow the ministers always forget to sign that date for the implementation of the legislation. I think there was another question he asked concerning whistleblower. Yes, our legislation does not have whistleblower protection in it. The ordinance does not. When we looked at other jurisdictions, many of them do. But however, I think we had written some amendments that we were contemplating to be done, and we had presented them to the legal advisor. Whether or not those were taken to the full cabinet for discussion, I can't say, but we did include something to do with whistleblower in that in those proposals that we had put forward. So we see that the ordinance needs to be updated. We have made suggestions, but again, we can make suggestions, but if the executive, through the legal advisor or whomever, decides not to act upon it, then there's not much that we can do other than to, how we would say, lobby, cajole, and see if anything would come of our lobbying.
Yeah, and Webbo, in relation to the caller, while the commission is independent in its operations, or supposed to be independent in its operations, we are not independent from the system. And so we will need investigative support, from whether it is white collar crime unit or FIU, and at the end of the day, whatever we come up with must be sent to the Director of Public Prosecutions. And so we still work within the system. And again, the Director of Public Prosecutions is a public officer.
Yes.
So
go ahead.
they expect us and we expect them to act, with integrity in relation to the whole system.
So, in other words, this is just another unit of the overall system in terms of our society.
Something like that. And it can work if persons, take their roles and functions seriously.
Well, let's hope that it works out. As you said, we keep working, right?
Yes, we do.
Okay, the final word from Mr. Chairman.
Yes, Mr. Herbert, thank you for allowing us to come in to, this evening, tonight, to basically present to the public, to the people of Nevis, information concerning the Commission, and to say who we are, what we do, and how we seek to follow the mandates of the ordinance. Yes, it is, there are going to be ups and downs, and as we move forward, we implore persons who have not filed their declarations to please do so. We do not wish to take anybody to court. We do not wish to publish your name in the newspaper. But at some point in time, if you refuse to do what is required, then we then have to then follow the mandates that are given to us by the ordinance and move forward. So thank you very much for inviting us. And to the general public, thank you for your support out there. And we will seek to work, with the persons and from strength to strength. And we will be back at some point in time in the future to give you updates.
We'll appreciate that. And as you say, it's a working process, and maybe over time we'll get there.
Yes.
The Integrity in Public Life Commission. Mr. Keynes, Ricardo Keynes, the chairman and the commissioner. Mr. Newton, Sidney Newton, commissioner, and also Mr. Alfred Tyrrell. We thank them very much. We thank you for listening. We thank you for participating. This program repeats tomorrow morning at 10 o'clock following the VON News Minute. Join the Honorable Mark Brantley tomorrow evening for 8 o'clock for On the Mark. Thank you all again for joining us. This is your voice in the community. Thought that get results. You all have a wonderful evening.
The views and opinions expressed on the preceding program are solely those of the participants and do not necessarily reproduce the news broadcasting company limited or its